Welcome to Perspectives. And particularly we're interested in the new viewers that are watching our program today. This is our 65th show. We've put on in the last year and a half 65 programs dealing with a whole host of discussions and issues relative to Sarasota. The title of the show is Perspectives, and the reason for it is to give you a different perspective on issues, particularly issues surrounding you. What we're interested in your knowing is some background of some of the things that we've put on. We've had the county commissioners on this show. We've had Jeannie McElmurray on talking about Midnight Pass. We've had Bob Anderson on talking about hurricanes and hurricane preparedness. We've talked about the manatees. We've talked about porpoises. We've talked about Save Our Bays. We've talked about the bays themselves, panthers. We've had a whole host of programs dealing with the environment, and so we welcome you to the show. And today we've got another special program. I don't know whether you want to call this typical of what we do, but we're going to talk today about the environment and law, and we have as our guest Judith Kavanaugh, an attorney in Sarasota County. And Judy, thank you for having enough nerve to show up today.
It's my pleasure.
I appreciate that. Judy, to my knowledge, you're one of the first environmental lawyers, if not the first environmental lawyer in Sarasota County. And I must tell you that I appeared before the Hillsborough County Bar Association about 1967 or 1968 and pleaded with them to endorse the concept of environmental law, and they turned me down flat because they said it was a passing fancy. I then went to the medical profession in Hillsborough County, and the medical profession immediately formed two committees dealing with the environment and health, and were very, very responsive. So when I came to Sarasota, I found that you were here and you were dealing in environmental law, the first environmental lawyer. How did you get into it, and can you define environmental law for us and tell us the difference between environmental law and normal law, what normal case kinds of materials?
Well, actually, environmental law started out in the 60s, and as environmental regulation became more comprehensive. And as the regulations grew, then it became a more and more specialized area of the law because the regulations are very technical, they're very comprehensive, and it's hard for a person who's trying to maintain a general practice to keep up with the regulations. But originally it was more of a subset, I'd say, of real property law. You'll find a lot of environmental lawyers started out as property lawyers, and gradually, as their clients, particularly development interests, got into more and more areas where they were being regulated in the context of effect on environment, these lawyers had to pick up expertise in that area. And when I was in law school, my law school didn't even have a course on environmental law. They had a course on administrative law, which is dealing with agencies and their regulations, and that was considered a very, new sort of a topic. I came back to Florida primarily to be a general practitioner, but early in my practice I was a member of the Isaac Walton League, and they were embroiled in a controversy south of here, or north of here in Manatee County, over a refinery that at that time was coming into Port Manatee.
I remember that because I was in opposition to that from the Tampa side. We didn't think that was a good idea because they were going to build a small one, but we knew that if they got a small one and they found offshore oil, it was going to be huge.
Right. And, I was a new lawyer right out of law school, and so I started helping the Isaac Walton League with that case, and discerned immediately that the other lawyer, who was an air pollution lawyer, in fact it's gotten so specialized now, you have air lawyers and water lawyers, even different expertise within it itself. He was really the only one in the whole state, and just by virtue of being involved in the case, I became known as an air lawyer, and gradually people would come to me for advice in environmental matters, private clients and public sector clients, and over the years I've been very fortunate in that I and my firm only practice environmental and land use law now. We're probably the only firm in the state, though, that's that lucky.
Well, let's give your firm a plug. What is the name of the firm?
It's Peoples, Earl and Blank, and we right now are the only statewide environmental and land use law firm. That's all we really do.
Well, you used to be with Jim Gardner's office.
Yes.
And you were their environmental prosecutor.
Right.
Recently, I saw in the paper where the cabinet. Is it the cabinet? No, the Supreme Court of the state of Florida rejected State Attorney Gardner's attempt to interfere, I guess, or I don't know what the right legal term is, but to stop the GDC development or dredging and filling. Can you tell us the basis of his suit, one, and two, why the Supreme Court turned that down? Because it seems to me that any time that the environmental side gets beaten by the law, there ought to be some cause for concern as to why it happened.
In this situation, I wouldn't exactly say that the environmental side had been beaten by the law. In fact, the end result of the underlying controversy resulted in the largest fine or negotiated settlement that the state's ever seen, at approximately $5 million over a period of years. What had happened here was there was a legal controversy over whether General Development Corporation was authorized to dredge and fill in some canals that they had. It was a pretty old development. It had been formed under an old drainage district. The Department of Environmental Regulation, which is the agency, as you well know, charged with the responsibility to enforce the laws, initiated an enforcement action against General Development Corp., and they were in the process of negotiating that situation. Mr. Gardner decided that it was not moving quickly enough, or he didn't like the way it was going. The state attorney's office was not really involved in that enforcement action other than tangentially, and filed suit in circuit court here in Sarasota County, specifically on the basis that he had separate authority to enforce the very same statutes that DER was enforcing. So the legal issue really was, can the state attorney enforce every single law in the state of Florida, regardless of whether or not there's a specific statute authorizing him to do that? For example, in the DRI statute, Development of Regional Impact Statute, there's a specific provision that says the state's attorneys are supposed to enforce its provisions. Under 403, only the Department of Environmental Regulation, and sometimes Health and Rehabilitative Services, a health agency.
So it's really the issue that the Supreme Court of the state of Florida reacted to,
right,
was whether or not he had jurisdiction.
Exactly, and they found that he did not. As a state attorney, he could have come in under the citizen suit provision as a citizen and maintain an action.
That's kind of a big case, and I suppose it's a precedent setter.
It was a first impression case, yeah.
There are a whole host of things that really we could talk about. One of the issues that I would like to talk to you about, and I was involved in a case some time ago with the State Attorney's Office in Tampa. It dealt with a phosphate company on Tampa Bay that was discharging an awful lot of fluoride into the bay. And when I presented the data that we had in terms of the chemistry and its effect on the environment and the fact there wasn't a living organism, there wasn't any grass, and the temperature was 94 degrees or something like that, the state attorney, in looking up the statutes, concluded that the basis for the issue was whether or not there was a sufficient mixing zone. And although I can't speak to the law, it seemed to me that what the law was written so broadly that in fact there was no law, because I said to him, my interpretation of the statute is that all of Tampa Bay could be a mixing zone, because until you can't find anything, it's the mixing zone, and the mixing zone was not defined by distance. Is that still the case? Is my interpretation of that correct?
They've tightened up the mixing zone rule now, and there has to be, in any permit, there has to be a specific aerial definition of how far the mixing zone is going to be. Is it going to be 3,000 feet? Is it going to be 100 feet? But the first mixing zone rule was very vague. It was very difficult to determine, or to advise a client exactly what to expect when you're trying to get a permit. And the state attorney's office is put in even more an awkward position, because to prosecute things under the criminal statutes, and there is a criminal several criminal statutes, in fact, that relate to the environment, you have to prove it beyond a reasonable doubt. So if there's ambiguity in the rule that you're trying to press in the first place, it's very difficult to prove the requisite intent and beyond a reasonable doubt that the crime's been committed.
Well, I know I've seen, my picture's been on the paper recently, but yours has been there too, Judy, and I know that you're involved in the city's land spreading issue, and I know that there aren't an awful lot of things that you want to say about that, but I think it's proper to give recognition to the fact that you are in fact involved in that. A couple of weeks ago on this show, we had a program, and we were dealing with an individual, and we were asking whether or not whether or not there were panthers there. We were doing a show on Florida panthers. One of the issues that you brought up, and what I mentioned in that particular show was that I thought that was kind of creative on your part to come up with an endangered species concern, because if I'm not mistaken, you talked about eagles, you talked about panthers, and I don't recall...
The wood stork.
The wood stork.
Gopher turtles, they're threatened.
Right. Well, as a matter of fact, go ahead, did you have...
I was going to say the sandhill crane is also listed.
The current status of that, there was recently in the newspaper a public notice by the Department of Environmental Regulation. And without going into an awful lot of detail, if you could hit the highlights of the significance of what it is that DER is asking in that public notice. What are they asking?
The notice that was published, I think it was published this morning in fact, relates to the city's request that it be permitted to use the wetlands that are existing on the spray site as part of its treatment system. In other words, the effluent, the sewage, treated sewage coming from the plant will be sprayed on this huge site where there are existing wetlands. And the DER has to give a very specific authorization for existing wetlands to be used for pollution treatment. And that's what the city was speaking. The notice that has come out is on a fairly narrow aspect of the project, and it poses some very stringent conditions, which I'm glad to see. Obviously, we don't agree with the intent. We think the environmental issues have not been fully addressed.
Well, but that notice does call for input from the public, if
Yes.
I'm not mistaken. If
Yes.
anybody's concerned about that, they can write...
They should write to the Department of Environmental Regulation. They're calling for comments now. Right. We are hopeful that we are going to get a hearing out of this. In fact, I feel certain that we will, in order to examine all at one time the environmental issues that this presents. There are other permits they're going to have to get to.
But this one strictly is for the land spraying area.
The site
it has nothing
itself.
to do with Van Drype Slough.
No, it has only to do with the site itself
Okay.
and the use of those wetlands.
Okay, so if the people viewing this are concerned about that, they ought to pick up that notice and drop a line to DER.
They certainly should.
Another thing that DER is involved in recently is the potential classification of Sarasota Bay and the other bays to our south as Florida Outstanding Waters. A local attorney in town wrote, I guess, to the county commissioners and indicated that there would be an economic hardship or disadvantage if that were to happen. The Sarasota Sun, I think, wrote a blistering editorial about that, saying that that was just atrocious that anybody would be opposed to making these outstanding waters. Can you tell us something from your standpoint, from the environmental law? What are the advantages and disadvantages of declaring these waters as outstanding waters? Mm-hmm. And then subsequent to that, after you've gone through that sequence, is there really an advantage to doing it in the long run?
Well, what the purpose of the Outstanding Florida Water designation is to afford a higher protection to unique bodies of water in the state, something that's different than generally the waters you find in the state, and preserve the water quality and the development impacts on that body of water. What it does is change the level of permitting required. You're going to have to get more permits if you're going to do something that affects an official outstanding Florida water. Micah River is an outstanding Florida water, for example. At least it is as far as it flows in the park. The problem I've seen over the past few years is more and more of these petitions are being filed, and more waters are being designated as outstanding. And I think the danger is, if every water in the state becomes an outstanding Florida water, then the tool for protection has lost its effectiveness. Now, personally, I think Sarasota County is a unique body of water, Sarasota Bay, and it deserves that protection. But I think caution should be taken in using that mechanism.
Let's pursue that, because I might take a different stance with you on that one. Let's use the argument that was presented in the last session of the legislature relative to the protection of wetlands. Mm-hmm. Now, I don't know how you can't say, well, if we say all wetlands are important and these kinds of wetlands are important, if we're going to dilute the rule. Maybe the facts of the matter are that at least along Florida's west coast, all the way down to Key West, that they are unique waters. They are in subtropical to tropical waters. They have a unique biota. It's a tremendously unique system, and maybe they all are outstanding, and maybe the only way to protect them of what's left is to say, we're not going to dilute the law, but by cracky, we're going to finally recognize that there's something there important that we have to save. Now, isn't it just as possible that could happen? I appreciate where you're coming from.
The question is, what's outstanding? Is it outstanding in terms of state interests? Is it outstanding in terms of unique habitat or a unique system? And what's happening is petitions are coming into the ERC, the Environmental Regulation Commission, to designate every creek and river in the state by somebody who says, well, I don't want any development here, so I'm going to make this water outstanding. And my problem with it is the criteria they use. I agree with you. The waters on the West Coast probably are unique. They probably are and deserve protection. But if all the rest of the waters in the state are afforded that same protection, sooner or later, there will be no protection. We will have really nothing better than we have now, which are water quality standards to protect your normal, everyday water, as it were.
Well, okay, we're not terribly close together, but we're not terribly far apart. Let's go to another particular issue. Well, what are the disadvantages? We didn't discuss the disadvantages of having things other than, are there any other disadvantages other than the generality of the rules?
Outstanding for Florida water?
Yes.
The disadvantages are economic. They more economic in nature, and that is that you have a heavier burden to carry if you are planning any kind of development, from building a single-family dwelling to a large development or some small industry on an outstanding Florida, or that will impact an outstanding Florida water. Your burden is greater. That's not to say it shouldn't be greater, because the whole idea is to protect this unique water body. But what it does is it makes it harder for you to get permits, basically.
But aren't we looking at a progression of knowledge? We initially dumped our raw sewer in the bays and in the rivers, and those flowed to the bays. And then we went to primary treatment, and then we've gone to secondary treatment, and we constantly see, and we've had dredging and filling. And the flash of green and Bird Key is a classic example. We've had developments, we've had stormwater runoff, and we learn more and more about the disadvantage that has in the environment. And finally we're saying, hey, wait a minute, it's time. I would argue, and I assume that you would agree with me, I would argue that good development is good for Florida, and bad development shouldn't happen.
Right.
Well, if you're going to put in a development that has a serious impact on a water body, for instance, I've been harping about a particular development south of us in Sarasota County, and currently the cross-sectional area of the ditch that drains that particular segment is something on the order of 63 square feet. And what is proposed is a ditch 100 feet wide, 6 feet deep, 35 feet wide at the bottom, 100 feet wide at the top, with a maximum velocity of something like 3.2 miles per hour flowing off that. The cross-sectional area is now going to be 190 square feet or something like that. What that's going to do in terms of the salinity in Lemon Bay is just absolute destruction, and we know it in advance. If we had some rule that says, hey, guys, you can't do that, and although I think we do have the rules on the books, I think there probably are laws on the book in terms of water quality to enforce. I think there are, Vicki Schenkel would argue that she doesn't have enough people to enforce what she's got, and she's always asking for more people. And I think that may be one of the issues. Do you think that's a...
I think that is. I think the department has come a long way, Department of Environmental Regulation, in their enforcement efforts. But one of the most favorite things for the legislature to do is to pass wonderful environmental laws, then fail to provide the funds to the agency to enforce them. And that's a continuing problem. Individuals, for example, you could petition for a specific rule to address this problem. The agency, I think, would probably agree with you. I think the Environmental Regulation Commission, which is pretty environmental conscious, would agree with you, but then who's going to enforce it? The local governments have limited funds too, and limited resources, and I think it's a continuing problem. We get more regulations, but not enough money to do anything about them.
We mentioned on this show a couple of weeks ago that the Florida legislature a few years ago passed Panther bill, Panther Research Fund.
Right.
Didn't put any money in it.
Right.
Okay, said to the public, you know, if you want to preserve the panther, throw some money in here, we'll do some research about the panther. And that's in essence what's happening here.
Yeah.
The federal government passes rules, and they don't provide money to the state to enforce them. The state passes rules, and they don't, you know, so it's up to people like you, I guess, to catch them on one side or the other.
Well, I think that's where the environmental groups, particularly in this area, this part of Florida, have been very successful in representing private clients and public governmental bodies. I know what an effective environmental group can do, having also represented environmental groups. They push the law, and they basically push all of us forward to comply with the regulations and for the law to develop. And I think we're very fortunate on this side of the coast to have very active groups, very knowledgeable, reputable groups.
Keep talking. Those are nice words.
But I think people like you and like Gloria Rains and Minnesota 88, Selvar Base, we have very activist environmentalists here, and it has done nothing but help the system as a whole. It's made the development interests more conscious of their responsibility under the law. It's made public bodies more responsive to the desires of their constituencies. So I wish the rest of Florida were as activist as we are over here.
You touched on a thought that I'd like to explore. You're in a law firm, and your law firm, you say you deal with environmental law, and probably all of you started out as what are in the vernacular called dirt lawyers, I would guess. And that's not a bad term, that's just what, you know, land and so forth. Is there a possibility that you could get into a conflict of interest, you personally could get into a conflict between you and your partners because they might be going in for a development and you could be going in opposition, not to that development, but to something else? In other words, is there a potential for your partnerships to fall apart because you're coming from different directions?
Your question was, do we have conflicts sometimes internally where I'm representing an environmental side and perhaps someone else is representing more of a real property sort of a question?
Right.
There's a potential for that. But we, like all law firms, have a mechanism where we try to resolve conflicts before we take on client representation. And you do have to consider new client representation or new issues for the clients you have in the context of what you're doing for another client. That's why, for example, we represent quite a few local governments. I've been Hardy County Attorney. We've been phosphate counsel to Hardy County and to Manatee County. We have never represented a phosphate company because that there's just too much of a potential for conflict in that sort of a thing. But as far as there's a potential there, I would say it's not threatening to us any more than any other law firm because you solve those right off the bat. Well,
then let me ask the next question. Was there a conscious decision on your part and on the part of your partners in taking on the land spreading issue that there would be a potential problem between yourselves and the city down the road?
Well, I wouldn't say we all sat down and we said, well, you know, this means we will never be able to appear before a city commission, because I think the commissioners are, you know, they're neutral people, and I don't think they hold it against any attorney necessarily for the position they take. Certainly, though, when we did take this representation on, and we took it because we believe that it's a very meritorious environmental issue, we were aware, in light of the atmosphere of the conflict, that we would be perceived as being in a very hostile posture towards the city, and that could affect in some cases, perhaps individual commissioners' attitudes.
Yeah, but Judy, I applaud you because somebody has to defend the guilty, somebody has to defend the innocent, and you people are playing an important role in what you're doing.
Well, as I say, there's 2 sides, 3 sides, in the Sprayfield case, probably about 8 sides to every issue. And I found in dealing with public officials, both as representing them, appearing before them in different contexts, that the responsible public official, and I characterize the City of Sarasota City Commission as being very responsible in their desire to solve a terrible problem. I mean, they've got a problem with their sewage treatment system, and they're trying to solve it the best way they can. And they've been very receptive, in my opinion, to hearing from the public. The difficulty that we have had is that there's been some problem with structuring of the facts and structuring of the context in which facts are presented. I have no doubt that the City Commission is trying to do the right thing, that they're environmentally conscious, and I'm hopeful that we are going to be able to fully explain our position to them.
Well, you know, I've appeared a number of times before the City Commission, and your reaction is my reaction. I think they're a very responsive group. But, you know, I have a feeling, and I don't know whether or not it's a fair feeling or not, but I think that attorneys talk to attorneys differently than people in political office talk to attorneys. In other words, it's possible that there may be some posturing going on, it seems to me. I mean, attorneys seem to posture, you know, like two peacocks facing each other and ruffling their feathers, when in fact that may not necessarily be the issue, but they're all, you know, they're all getting lined up, and maybe that's what the issue is as perceived here.
Well, I do think that the Commission itself perhaps has a view of the facts that's somewhat narrow. I mean, they're limited by what they're told.
Right.
And I see that as one of the problems in our case, and is just that there hasn't yet been a full exploration of all the facts.
Let's talk about one other issue, because there are a host of things that I wanted to get in today, and there isn't any way to do that. But one of them is barrier islands and their protection. There is an attempt at the state level and at the national level to stop national subsidizing or subsidy of at the national level of barrier islands by federal roads, by bridges, by loan insurance, by flood insurance, and by loans. What's the state of Florida doing to implement and to extend that?
Well, Governor Graham has always had as one of his main concerns the protection of the barrier islands. In fact, he instituted an executive order 5 years ago, which really was the only tool you had, other than the coastal construction regulations, to protect undeveloped barrier islands, which are essential, of course, to our whole system on the West Coast, and the East Coast too, but we have more undeveloped ones over here. He was very influential, and his office was in getting a very strong set of statutes enacted this past session, which specifically address coastal construction and the barrier islands problem. Some of the environmental groups feel it did not go far enough, but it went further than anybody else has so far.
Well, it does speak to the undeveloped islands.
Yes.
It doesn't, for instance, Longboat Key is not an issue.
Well, no, in the new growth management bill, in fact, it does place obviously lesser stringent requirements, but it does regulate existing development and give some protection to the areas that are already developed to ensure that they don't get overdeveloped or cause a problem.
Judy, environment and the law. I thank you very much for coming in and sharing your views with us today, and we thank you for participating with us. If there's a program that you'd like us to put on, if you'd give us a call at 371-4444, we'd try to put it on for you. I'd like to make a couple of other comments before we go today, and that is, first of all, I want to thank Judy for showing up, because in light of the controversy that's been going on in the last couple of weeks, I think it took some nerve, and I thank you for doing that, Judy. Secondly, I think it's important that the viewers realize and understand that the program is put on for your benefit, and you ought to participate in it by providing us with some ideas concerning what you'd like to see. So if you'll give us a call, we'd appreciate it. Thank you for viewing.